Hi, you guys. Like, subscribe, and hit that notification button. I had to do this video. I'm doing this video really for two reasons. One, I found some tea out that I had to share about the Chrisleys, and why not, throw it in with the ankle bracelet because that's the new thing that everyone's talking about. So why not? So anyway, Chrisley knows best. As you guys know, he was found guilty. I have a bunch of other videos about it if you want to learn a lot more about his case and the process and all that. So I guess they have put an electronic monitoring device on the Chrisleys as they wait their appeal and in the process of already being found guilty. So I thought you might be interested in what it's like to wear an electronic monitoring bracelet, but I have other gossip I'm spilling in this video. First of all, it's not that heavy, but it's pretty heavy. It's a bit clunky. It definitely is uncomfortable to wear. You can't wear it in the bathtub. Can't get in the water with it. If you put it underwater, it'll malfunction. So they ask you not to do that. And when it malfunctions, it automatically sets an alarm off, like you've cut the bracelet. So then the cops come. Can you imagine? You're like, shit, I just took a bathtub by accident. Anyway, you can shower with it and you can get it lightly wet. Surprisingly, I've seen people in Miami Beach walking all along the shoreline with their EM bracelets on, their electric monitoring bracelets on. And I always think to myself, I don't think your officer knows you're at the beach. You must live close to the beach. And he thinks you're like at home right now. People and rules. What are you going to do? Anyway, I always think they're always young people. So, they're like in their 20s or something. So I kind of feel bad. Like, oh God, they've already got this issue, whatever it is. And they're just babies still. Very depressing. Okay, we'll move on. So they set the bracelet and everything. You're allowed to go to school. You're allowed to grocery shop. You're allowed to go to and from work. You're not really allowed to do anything social unless you get permission. Some people have to stay in a proximity. The bracelet will go off if they're out of their proximity that's been set. So they have like a program, a computer that they can set where your work is, where the school is, where your home is. Yeah. And if you cut the bracelet, it sets an alarm off. There's been some crazy stories about people with their EM bracelets, though. Because, supposedly, too, if an EM bracelet doesn't move for a long period of time, it also will alert an officer because it shows that it could be being tampered with because obviously you move. So supposedly there is another trigger with that. So anyway, there's a famous story about this fraudster. Here, I'll tell you a good EM bracelet story. So there was a guy named Paul Ceglia, and Paul he sued Facebook saying that Mark Zuckerberg stole his technology ideas from him or whatever. Anyway, Mark Zuckerberg stealing from somebody else didn't bother anybody, but apparently in this case, it did. So they said Paul Ceglia was a liar and they indicted him. He was an entrepreneur, a little bit too risky entrepreneur. He is a founder of businesses such as Green Springs Natural Cemetery, Street Facts, Pagebook, and Allegheny Pellets. In 2010, Ceglia bought a lawsuit against Facebook Inc., claiming ownership of 84% of the company. The judge dismissed Ceglia's claim as fraudulent. Ceglia and his family were found to have vanished on May 1st, 2015, after he cut off a GPS tracker, an EM bracelet. In 2018, he was arrested in Ecuador, where he remains after the country denied the U.S. Justice Department extradition requests. It's such an interesting case. Basically, what he claimed was he and Zuckerberg were undergraduates at Harvard, And he entered an agreement on April 28th, 2003 with a fee of $1,000, which entitled Ceglia to 50% of the website revenue, as well as an additional 1% interest in the business per day after January 1, 2004, if Zuckerberg was tardy in deploying the site until the website was completed. The purported contract obligated Ceglia to pay Zuckerberg $1,000 for Street Facts and $1,000 for another project called PageBook. The contract also mentioned an expanded project called The Facebook to be completed by January 2004, charging an additional 1% interest in the business owed to Ceglia for each day the website was late. Ceglia proffered a $1,000 receipt from his checkbook dated 6 months after the contract as evidence that he paid Zuckerberg for his work. Because remember, originally Zuckerberg was a student at Harvard doing like work for hire for people. And in fact, that's the whole scandal with Facebook, is that two very wealthy kids that were from rich families, Zuckerberg was, not from a wealthy blue blood family. Anyway, these two rich kids come up with the idea for Facebook, and Zuckerberg is developing it for them. And then he just like, what do I need you for? And he steals it. Okay, and he makes it his. And then they sue him, and they do win damages, but not nearly what they should have gotten for the fact that it was really originally their idea and he was work for hire. So anyway, this guy claimed basically that he had an agreement that was very informal with Zuckerberg as a hired developer in a similar scenario that he set up. But this is the real clinker here. Zuckerberg admitted to having worked for Ceglia on streetfacts.com, but claimed that Facebook was an entirely separate idea that had no relation to Ceglia. Ceglia and his lawyers have claimed that Facebook planted a fake document on his computer to incriminate him. The evidence presented by Ceglia was determined to be fabricated. While he was under electronic monitoring at home, he built a stick and a motor with a gauge. And he put the bracelet, somehow got the bracelet off of himself. And he put the bracelet on this contraption. And the contraption would move it around the room so that it appeared that he was always moving, because he believed that the electronic monitoring not only tracked where he was and his location, but also movement. And if it stayed still for too long, then he'd get busted and the cops would come. So he builds this whole machine. He grabs his wife and his kid, and I guess to Ecuador. And that's where they catch him. And then but they can't get him back to the US. So he's in Ecuador. He's probably he's a Harvard grad. So I'm sure he's like, a Harvard guy. So he's probably doing something for the Ecuadorian government. He was under electronic monitoring. He actually hadn't been found guilty yet. They were doing his trial and he split before the trial because he was facing 40 years in prison. And I guess he felt like there was no way he was going to win against Zuckerberg and Facebook coming after him with the prosecutors as well. So he just ran. Anyway, it's a wild story, but it's a really good story to show the example of like EM in a pre-trial situation. Chrisleys are already guilty, and they're going to have their EM bracelet to make sure that they don't try to flee now that they know they're guilty and they're appealing. It's definitely awkward. You can't wear skirts or dresses, which won't be a problem for Todd, but Julie's going to find that difficult. You have to wear jeans or baggy pants, boots. It's so crazy. The government to rent it. I think it's $80 a month. It's like $60 or $80 a month. You have to pay the government to rent your bracelet while it imprisons you. Yeah, what other fun things? Oh, you have to return it like a Blockbuster video. They deliver it when you get it, but then you have to return it with all its equipment, or they charge you for it. It's just like a Blockbuster video. Anyway, some fun EM facts for you. But in all seriousness, you don't ever want to have to wear one. So it's not the accessory you're looking for, this bracelet. All right, so I did want to find something out because, I always tell you guys, keep an open mind no matter what. So I was going through things, and I went back in time using one of my legal resources, and I found a case that was from 2012 for racketeering, and it was the Chrisley suing Mark Braddock who is the gentleman who testified against them in the current indictment, they had pursued him for racketeering charges and fraud and all these, and doctoring statements and all these things in civil court. The case seemed to be dragged on and on and on. They did, like, Julie and Todd did a massive complaint, but then they never did their like statement of claim or whatever. You know, they have to do a follow-up statement of claim. They never filed it. So it was like they did their complaint and then it like they just kept pushing it out, and they never did that part. And then I think they just dismissed the case. So what I'm assuming is that there's only two possibilities, okay? Either the Chrisleys knew something was happening bad and this gentleman had turned on them. So they, did this civil litigation to kind of, control who did what. So they basically made all these allegations against him and people he worked with, and that he was doing fraud and he was bullying employees and he was stealing money. And he was creating competing businesses and he was holding checks and not paying people and causing financial misery with them. And guess what? I saw numbers in there that match the current indictment case, but for a totally different reason. How's that? Yeah. Want me to read you an example? So now I'm wondering who to believe. I'm not sure I believe Mark Braddock, because this complaint existed in 2012 and the Chrisleys are calling out all these horrific things with exhibits now, given they kind of lost their steam on it. But what kind of credibility does this guy have? I don't know. And at the same time, the Chrisleys, they were found guilty by their jury, because I guess Mark Braddock's testimony was compelling. But so in this case, that this is actually was taken specifically by Julie Chrisley on behalf of a lot of the companies, because surprisingly, Julie is running a lot of her and Todd Chrisley's companies. So she's taking it as the head of their multiple companies against Mark Braddock. And it's filed on October 9th, 2012. And here's one paragraph 35. On June 11th, in the complaint, on June 11, 2011, defendant Mark Braddock made 6 cash withdrawals on one day of $9,500 each, an amount presumably to avoid federal suspicious activity reporting requirements for cash transactions over $10,000. Mark Braddock was hiding important performance data from the Chrisleys and ordering employees to lie on his behalf. Furthermore, Mark Braddock was found to be using stamps with Todd and Julie Chrisley's signature without approval and after specifically being instructed not to do so. In addition, Braddock presented himself as Todd Chrisley to banks and credit card companies in order to receive card benefits and exert control over his partners. And then they submit an affidavit of Donna Cash. As part of their investigation, plaintiff also recently discovered that Mark Braddock, in concert with defendant Clary, was creating and using false and fraudulent audits and financial statements allegedly prepared by the company's certified public accountant and submitted to banks and clients. On information of belief, including the sworn testimony of a CAM's accountant, who has reviewed the fraudulent document created in the name and forged with his signature. Defendant Mark Braddock stole the CPA's stationery and a copy of the CPA's signature to cut and paste together these audited financial statements. Now, here's a document that was put together in 2012. And Julie Chrisley is saying that these payments were withdrawn, same amount, by the way, that they mentioned in the indictment. They were withdrawn for the purpose of Mark Braddock trying to hide money from the government as he took it from the Chrisleys. Now he's saying that he withdrew money from his own bank account of $9,500 and paid it to Todd Chrisley. And he did that under the guise that Todd Chrisley, someone had told Todd Chrisley they were going to call him out as a part of the LGBTQ community because he was having an affair with Mark Braddock, purportedly. So which is it? I mean, you're not supposed to file a complaint with a legal inaccuracy. And certainly you can put anything you want in a complaint, but you're not supposed to lie. Let's just say that. And Mark just testified under oath. Now, I even looked at the date because I said, well, could it just be the amount is similar? Although that is such a strange amount. And it was June 11th, 2011, and that's about the time frame in the indictment. So I wonder, there's a part of me that wonders, I'm pretty sure this litigation was not admissible in the indictment, but I wonder, I wonder if the prosecutors were made aware of some of the statements in this original claim against Mark Braddock or not. To me, as a jury person, I mean, I don't know, the rules of court may not allow you to look at civil litigations, but it would be pretty compelling that someone filed a 78-page civil litigation back in 2012 when this relationship broke down, and some of the facts in this document, there's numerous allegations in this document against Mark Braddock that he purportedly did fraud. It's not like they were like secret about it. It was like in this document, they were like, on behalf of us, he made these illegal documents and submitted them to banks. So I know that they were saying that was their defense now, right? But what I didn't know was that they had a full-blown civil litigation complaint and evidence documenting it way back in 2012 before the indictment. And to be fair, although Mark Braddock flipped and signed an immunity plea deal, I think, which is, I told you in my last video, I think that's just insane. But, as I'm reading this, if even a percentage of this is true, he's not credible. Just saying. I want people who deserve to be punished, not people to be punished for the sake of a system. You know what I mean? And I know that's a delicate line to walk. I'll read you one more part and then I'm going to call it because I'm exhausted. Long work day. Another section. I mean, Mark Braddock had a company that purportedly was competing with the Chrisleys, and he was trying to steal their clients. He had motive from that perspective. He was trying to, unless this entire thing was fabricated. And if this entire thing was fabricated, they maybe to make Mark, try to make Mark the fall guy for their fraud, which is, I'm sure, what the prosecutor probably argued. But some of the things in here are not even in the time period of the current indictment. There's other things in here. Like he was faking tax returns and I'll tell you. Hold on. So this is what Julie and Todd Chrisley said. Approximately 2 years ago, Todd Chrisley began receiving unsettling information about his partner, Mark Braddock, from several employees and others. Todd Chrisley was not present for most of the day-to-day operations of the business and allowed Mark Braddock, as part owner and manager, to operate in an independent and largely unsupervised capacity. Based upon information from employees, Todd Chrisley began investigating Mark Braddock's alleged impropriety with respect to Cam's business affairs. As a result of his investigation, Todd Chrisley discovered that Mark Braddock was engaged in ongoing illegal and unethical conduct, which was severely damaging to the Chrisleys personally and Cam professionally. On or about July 11, 2012, Mark Braddock formed a new company, U.S. Asset Management Partners, LLC, which Mark Braddock has represented would acquire portfolios of properties from provide REO management services with respect to those properties, and close the sale of those properties. As represented by Mark Braddock, U.S. Asset is intended to and would in fact directly compete with CAM, the Chrisley's company. Mark Braddock stated to employees that his reason for diverting this potential business away from CAM was to avoid sharing profit with the Chrisleys. See affidavit of Leland Nicholson, filed on August 14th, 2012. On information and belief, Mark Braddock has diverted CAM funds, employees, vendors, and other tangible and intangible assets of CAM to his company. Plaintiff, as a result of their investigation, also found false and fraudulent operating agreements for CAM and another company which Todd Chrisley formerly owned, but which had been dissolved. On information and belief, these fraudulent operating agreements were prepared by defendant Mark Braddock in this 2012 complaint. Defendant Mark Braddock has made repeated false and fraudulent statements to numerous third parties that he's a majority owner of CAM and that he has the authority which he does not lawfully have. Defendant Mark Braddock repeatedly represented to clients and employees of CAM that he was a majority owner of CAM and would soon finalize a plan to become the sole owner. Defendant Mark Braddock also routinely asked CAM employees to withhold pertinent and time-sensitive business and financial information from Todd Chrisley and to alter financial performance data to reflect lower performance and to reflect that CAM was performing on the lowest tier of Fannie Mae's metrics. This misinformation resulted in representations to the Chrisleys that the company's revenue was 40% below the actual revenue, given defendant Mark Braddock a substantial margin devoid from scrutiny of the majority owners of CAM, with which he and the bookkeeper, defendant Clary, could establish a slush fund to finance their illegal activities. Defendant Mark Braddock and Clary conspired to divert, steal, and embezzle money from plaintiff CAM. Mr. Nicholson, a CAM officer and portfolio manager, testified under oath in Superior Court action that Mark Braddock and Clary informed him that Embassy Bank had unilaterally seized CAM's receivables due to default on a personal debt of the Chrisleys, which was untrue. Mark Braddock and Clary also conspired together to hide money from Todd Chrisley, including opening a separate fraudulent bank account and preventing plaintiffs from finding out how much money the company had earned by falsifying and misrepresenting financial records. Okay, so these are totally different but related allegations that the Chrisleys are making in a complaint in 2012 against this Braddock guy. Now, I'm assuming that after this Braddock guy went through this lawsuit, that's when he whistle blew to the feds. But I mean, I don't know, like, if this is the guy we should be listening to necessarily, you know? I mean, there are affidavits in this document exhibited from people somewhat saying what they're saying is true. There's a lot of, aggressive allegations too in this that I don't see evidence for. I mean, could be fabricated. The entire thing could be them trying to divert their illegal activities off of them and onto him because they realize they're in trouble. But to me, it seems like there's like a lot of detail here. It just doesn't seem like he has clean hands. I don't think the prosecutors should have relied on his testimony because he's so questionable, although I know that's an easy case for them to use to make. I just think in the name of justice, someone that has that much documented and admitted, falsehood should not be included in someone's trial over their freedom. It's just they're too toxic. I think, in a fairer trial, what would happen is the prosecution would say, we can show that the Chrisleys actually created and directly themselves submitted this document and claimed it was true and it was fraudulent. This gentleman has admitted that he's got revenge and all these things. And I just don't know how you clearly can trust the testimony of someone, okay, well, this was him, being fraudulent and pretending to be the Chrisleys, but this stuff over here is not him pretending to be the Chrisleys and the Chrisleys really committing fraud. Like, that is a very hard line to understand at this point if this gentleman is this much of a fraudster as in this 2012 civil litigation states, right? Where's the line? How do I know what he did fraudulent on behalf of the Chrisleys and what the Chrisleys did themselves? Either these people are like the most diabolical, evil humans, and Julie is like the primary driving force behind this, or this Mark Braddock guy is an evil genius. I'm not sure who here, but there's someone here is definitely lying. I don't know. Wow. I have to ponder this one. Now, on the IRS tax evasion charges, I guess that, the government must have proved that beyond a reasonable doubt that the jury said guilty to those. And that is a big part of what they did wrong. I think in the appeal, the only hope they have on that front is if they can get a financial expert to re-audit the documentation and see if maybe they could present a different financial story to why they didn't pay taxes. But I don't know, that's a stretch. It's just pay your taxes. Don't overexpense, guys. Don't overexpense. Okay, you guys, that's it. My thoughts. Like, subscribe, and hit the notification if you like my channel and it makes you think. I adore you guys. Have an awesome week. Send me gossip. Wilkie_Dana on Insta. I'm a little behind, but I'll catch up. Don't worry.